breaking news or whatever. They're on another one. Gang, gang. Yeah. Gang, gang, emergency Zoom film at 11. Same 5 goons, same deranged obsession. This changes everything. Bro, it's page 47 of emotion they skin while half watching Yellowstone. Gang, gang. Squinting at 8-point font like detectives. Zoom so far and the pixels are screaming for mercy. Look at this, timestamps 2020, 22, my God. But they're yelling it like they just cracked Watergate. High five. Mike's been muted for 20 minutes, still barking. Circular logic, so a lot of time to seem impressive. Trust the plan, this is massive. Nah, fam, it's boilerplate and it's mid at best. Gang, gang. Self-appointed outrage, swat patting each other like they personally ended corruption. Gang. Dropping bombshell tea that's been sitting in pieces since breakfast. Gang, gang. Moral high ground speed run, they'll flip the script the second it's convenient. Gang. Same PowerPoint presentation, new day, same brain dead narration. Gang, gang. We're not obsessed, we're just passionate. 3-hour living yesterday's hoodie, passion in my ass. Why is he even breathing right now? Says the guy refreshing notifications every 14 seconds. Gang, gang. Playing lawyer on God mode, reading comprehension. Stuck in elementary, confidence in the stratosphere, case dismissed. They screaming to the void, motion still pending but go off I guess.
Disagree? Obviously a paid shill. Actually read the filing, deep state plan. Laugh at them, you're clearly compromised too. Exist in the same zip code, suspicious behavior. Notify the group chat. Gang, 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 gang.
Tighter circle, smaller brain.
Gang, gang.
Echo chamber finally running out of oxygen. Gang, gang. Yeah. Gang, gang, acting the actual judge like it's group chat. Replay all meltdowns, labeled just asking questions. Got warned by the core once, that was a suggestion. Still get it the same dumb screed like it's strictly trash talk. Gang, gang, we're above all this drama. While screenshotting, they on meltdown for content. Preaching peace and love while actively baiting bears. And fake shock when the bear finally bites back. How could this happen?
Gang, gang.
Synchronized tantrum hours. 5 tabs open, all the same screenshot. Different zoom levels, gang, gang. Premature victory lap. Over legal language, still can't pause.
Gang, gang.
Standing 10 toes on business until tomorrow's filing, send them scrambling again.
Gang, gang.
Hype the claim to the moon, then ghost the chat when it ages like milk. Gang, gang.
Gang, 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 gang. Gang, gang.
Refresh, gang, gang.
Gang, 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 gang.
See y'all same time tomorrow.
Gang, gang.
Don't be late.
How is everybody doing this evening? My, oh my, what a beautiful day it has been today. I mean, it is Thursday, which is like my Friday because, well, I don't have to work on Friday, which is going to be really cool coming up because Friday day, sometime during the day, I am going to finish out all of the, well, maybe not all of it, but I'm going to try to finish out the Afro Man stuff because it is absolutely insane. I haven't been able to catch all of it, so there's just so many things that keep coming up. Day was stressful, has to deal with that. I said, no fun, Jack. Yeah, it's been one of those. It's been one of those, but yeah. So I would have done that tonight. But I was like, I wanted to get through these documents because the judge, the grievance committee, they just slap them down. The sheep will say, good to see ya. Pardon me. I had some beautiful spaghetti that I made. Good stuff. And now it's like giving me the burps. I love it. Your kiddo was 10 years old? That's awesome. Well, congratulations, Jack. I mean, I can play this song there. You know, I don't know if it's appropriate. I don't think he's going to be drinking any tequila, but I mean, I can play the song. I do have that capability of doing it. If you want to hear it, just let me know. I'll throw it up there. I'll make it happen. I'll give you the beautiful song because well that's what I do. I like to be nice to you guys and give you what you like. I'll give him the happy birthday song. How's that? Here we go. And it's more for you. Happy birthday to you, 10-year-old.
Joyful time, it's your special day. Gather round.
so no matter where we are, tequila and margaritas, party through the night, cake and candles, the mood is just right. As the candles flicker, make a loving toast to the one we adore the most.
Oh yeah, happy birthday, man. That is so cool. That is so cool. I laughed whenever I read this. I absolutely loved reading this earlier. It was well, Volmit got all upset. He got so upset that he had to get down on his hands and knees and choke one out for old Paint Chip there. And well, he was working it harder and harder and over for him because, he decided he wanted to write a little bit about me. Well, because he's an idiot. Him and Paint Chips both are idiots. And it's absolutely hilarious. Whenever I saw this, I was like, oh, I've got to show this to you guys because what other kind of moron would show this but me, because that's the kind of moron I am. And what it was is he writes a violation of this order may be punished as contempt of court with sanctions, including fines or imprisonment. If the defendant continues in this practice, it will not end well for them. They should govern themselves accordingly. Well, most people heed judge's warning, but not Paint Chip. Instead, he came out swinging on Friday. Well, it was more like blubbing, it's just sort of shaking the blubber around, because that's what he does. He just sort of shakes it around a little bit. Let me readjust this really quick. Because I am a fool, just a fool for whatever. Here we go. That looks a little better. Now I got it where it's supposed to be. And so he mailed a response to the injunction, taking Judge Hinkle to task. issuing an injunction, a heavy-handed order without holding a hearing. How dare the judge do such a thing? How dare the judge run a courtroom how he runs his courtroom? Oh, he was especially perturbed by one passage in the injunction. I have read none of the emails. They have been intercepted by my staff and deleted. Well, Richard argued that if the judge didn't read them, he couldn't judge what was in the emails. He doesn't need to. That's what he has staff for. Oh, but it gets better. It gets better. Furthermore, emails to the chamber are part of the record available through open records requests, so deleting them probably violates all sorts of laws. Probably violates all sorts of laws. Oh, the injustice. Oh, the injustice. They're mutton flopping around. All true. Except Judge Hinkle also said, but the practice would be totally unacceptable even if the tone was professional. How dare the judge rule in his own court? As such, Judge Hinkle was adamant that parties stop including his chambers in their back and forth. The court would only address properly filed motions and other matters, not emails. For 10 minutes during the broadcast, well, Paint Chip went on a tirade about Jeremy Hales and his immature crew. In fact, the immature emails were written by Hales and his crew, like the following from Shizzywhiznut. You can't even spell it right. You are a retard, aren't you? You can't even spell shit right. It's Shizzywhiznut, all one word. There's no capitalization except for the first letter. You're an idiot, which I think is really funny. But also, I'm not part of Hales's crew. It's amazing how that works. Hales like employs people there in Ohio and Florida. I live in Georgia, and this is my show. I'm Shizzywhiznut, and you're not. And it makes you really jealous. And my response was, thanks for your concern, Paint Chip. It's truly touching that a guy whose biggest recent achievement is trading bar dues for bunk numbers still has time to play amateur marriage counselor. See, he didn't include in there what he actually wrote about him talking about my wife. Yeah, you notice that was missing from the whole article. Also missing from the article was the other threats that he's made. Amazing. All that stuff was missing, Vomit. It was all gone. Why was all of that gone? It might be because you're a fucking moron. Well, let's be real. You're not clever. You're just flailing. Throwing out lazy wife shots and vague practice digs because you've got nothing else in the tank except for coming after me like a little bitch. Well, it's an online equivalent of a toddler smearing poop on the wall and calling it art. By the way, my wife is doing great. The garden is thriving, unlike whatever barren intellectual wasteland you're cultivating, and her practice is busier than all your fake Facebook accounts and Substack alts combined. But please, Paint Chip, keep recalling all of those lonely cell block nostalgia onto other people's lives if it helps you sleep at night. Maybe one day you'll upgrade from government-issued boyfriends that aren't working it and harder and harder and harder and harder. Speaking of which, from what circulates in the right circles, you've also got a bit of a reputation that goes beyond disbarment and bunk time. Something about issues being around children. Or is it your orbit that includes folks slapped with restraining orders, barring contact with minors? Well, my memory's fuzzy on the details. Are the restraining orders against you personally? Your buddies on the no minor contact list? People raising flags when you're alone with the kids? I'm positive I'll nail it down soon enough. But since it apparently is a matter of significant public interest, your words, not mine, I look forward to your prompt, substantive, on-the-record clarification. Feel free to respond in detail. Sworn affidavits are welcome, and this correspondence, along with whatever evasive non-answer you cough up or don't, will be preserved and made public accordingly. If we go to press before hearing back, we'll just note the silence in the follow-up piece. Transparency is a bitch whenever your history's this ugly. All the best. Shizzywhiznut. See, it's not hard. The name's right there. See, Paint Chip? The name's right there. It's Shizzywhiznut, one word. Well, Shizzy, Volpe being the master class of intelligence that he is, he responds, Shizzy's a poor man's version of Carrot Top. Just below mediocrity is what he strives for. That's right. Absolutely just below it. Because if I hit mediocrity, I will have overachieved, and I do not like to overachieve. I like to do everything half-assed, just so you know. Still, Richard struggled to explain. Yeah, Richard struggles with a lot of things over and over and over, and struggles, and it could be, maybe he was dropped on his head as a child a few too many times. Maybe mommy didn't love him enough. Who's to know? But he wanted to try to explain why Judge Hinkle needed to make aware of the immature arguments. Needed to be made of immature arguments? Because, as I said, Paint Chip, it's fucking irrelevant, just like you. You are irrelevant. You're a waste of space. And you stepped into mine. And whenever something that large, comes into my orbit, usually I get sucked into it and I'm trying to push away, but it always ends up in some sort of half-ass crash. And it's your fault, Paint Chip. Here's a novel idea. If you don't like the remarks, if you don't like me responding back to you, then stay the fuck out of my life. Real simple. It's real simple. It doesn't take much. You don't sit there and accuse me of doing things that I haven't done, because I do have proof of the things that you have done. None of that explained why the judge's chambers needed to be included. Of course it doesn't. Finally, he explained what the hell's Andy's attorney, Randall Shockett, are liars with no ethics. They could say one thing in an email and something else in court filing. I'm sure he could, but that would be a waste of time. Sort of like your shit. In a brilliant move dripping with irony, Richard includes some of the emails as exhibits in his motion to reconsider. Well, only some of them, because if you would have showed all of them, he didn't include the prior emails. He also didn't include all of the emails that he was sending to other people on the internet, that he wants to throw into this mess. But, that's neither here nor there. But, well, Judge Hinkle, blah, 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 and it's just one of those kind of, paint chip. There's a reason why the Fleas channel is tanking every time that you go on there, because you are an absolute waste of space and you take up a lot of it, a hell of a lot of it. But the beautiful thing about it is I love how well the judge responded to you. I mean, the judge gave you every bit of irony that you deserve. Isn't that what you called it? Irony? It's amazing how that works. Irony. It just comes up, slaps you in the face. Sort of like Bubba. Right there. This is where we're going. Let me go back here. I got to do this and remove this because I'm an idiot. And stop that there. Right there. All right. Let me get this correct here. Damn it. Why did that do that? See, I'm messing things up all over the place. I will figure this out. Give me a second. Let me get that. Grab that. Delete that. There we go. So ridiculous. So ridiculous. Well, let's go ahead and pull this bad boy up because it's well worth the read, I guarantee. It's so well worth the read. I'll be listening until you start dozing. Hey, nothing wrong with that, Gwen. Order in denying the motion to reconsider the injunction not to send emails to the judges. Not just the judge, but the judges. All of them. Now, the moron or defendant, Paint Chip Jr., asserts a right to send emails to me and the magistrate judge in violation of the court's very long-standing prohibition of that practice. Now, he says that, his little Fifi's got hurt. He should be allowed to do this because attorneys can file materials on the docket electronically, while a pro se party, he can file materials on the docket only by email, which takes longer. Only by mail? Aw. This assertion, in effect, that Mr. Paint Chips should be able to bypass the requirement for formal filing of materials with the clerk's office and instead require the magistrate judge and me to maintain our own separate special independent files into what the retard Mr. Luthman can submit materials, apparently including materials that are neither motions nor responses to motions and could not properly be filed on the docket itself. Now, Paint Chips doesn't realize this, but this would impose an enormous unwarranted burden, and the clerk's office exists to maintain the files. A judge who attempted to maintain a separate docket would soon have time to do nothing else. Well, and that's what he wants you to do, because it's all about him, sir. It is rarely necessary for a litigant to bring something to the judge's attention immediately. Now, if Paint Chip thinks he needs to be able to do that, well, that little piece of shit, he can hire an attorney, or he can make any filing deemed urgent by hard copy delivered to the clerk's office. That, I know, of course, is less convenient, but most materials are not urgent. Filing them by mail ordinarily makes no difference. In any event, Whether pro se litigants should be allowed to file materials electronically is an important issue currently under study. In the meantime, Mr. Paintchip will have to follow the rules that apply to all. You're not special. Pro se litigants. It's ordered. The motion ECF 177 to reconsider the injunction prohibiting sending a copy of any letter or email to me or the assigned magistrate judge or to our chambers except when directly relevant to a pending motion, and then only as an attachment to the motion or a response filed in the docket, is therefore, Paintchip, denied. Denied. Robert L. Hinkle, United States District Judge. And that's how you give a big slap down to Paintchip. You just say, no. Stop. Early Tug Raid. Welcome, early raiders. Welcome, early raiders. We've got more for you because I had to go back and pull all this up. Now, the thing is Bubbles. Yeah, we're going to get into old Bubbles because, you know, he's a source of intelligence there. I mean, he's got the brain trust right there. You know, he went to school. He's schooled and educated. You know, unlike us retards over here, you know, I don't know anything. I'm just completely stupid and oblivious to, you know, things. like good evening, East X Cowboy. Chippy Mrs. Bubba. Yeah, he does. He does, Jack. He really does. He wants to, he feels it's so much, you know, and it just his loins are lost without Bubba. I think we should, you know, raise a toast to, you know, his lonely parts. Old 45 does it every time. Evening, Heather. Been a bit since I got to catch you live. Well, it does happen. It wasn't a slap down. That was an FU with a slap down. Yeah, that was. It was Marama. Said, nope, the judge ain't going to play this game. Now, let me take you back to late 2025. I mean, I could take you back even further. I mean, we could take you all the way back to 2022. Back in 2022, there was this little issue that came up of something that happened even earlier than that. And, you know, it was found that you know, somebody got butthurt, like really butthurt. Now, towards the end of 2025, you would think, you know, that they would have learned, that they would have thought, hey, you know, my license is on the line. Maybe I should behave. Maybe I shouldn't be doing things that are untowards in a you know, a setting such as this. So let me take you back to 10/17/2025 and tell you a little bit about this. This is an interesting little story. Now, this here is a statewide grievance committee, and it's dated 10/17/2025, as you can see. Office of Disciplinary Chief, and then, of course, you have Deuce over here with his little law firm. And this is Jones v. Matskin. There's Dear Respondent, Disciplinary Counsel, enclosed here with us this decision of the reviewing committee of the statewide grievance committee concerning the above referenced matter in accordance with the practice books sections 22-35, 2-36, 2-38, and the respondent may within 30 days of the date of this notice submit to the statewide grievance committee a request for review of the decision. A request for review must be sent to the statewide grievance committee at the address listed above. And what does it say? The attached decisions is presently stayed in accordance with practice books 235 and 238. Enforcement of the final decision, it just basically gives you the laws, and this is the parts of the laws that it gives you. But here's the decision. Pursuant to this, The undersigned, duly appointed reviewing committee of the statewide grievance committee conducted a hearing at the Superior Court on May 1st, 2025. Now, whenever they had this hearing, it addressed the record of the complaint filed on June 2nd, 2022. Took 3 years for them to get through to this, finding that there existed probable cause that when a respondent violated Rules 1.5b and 1.5c of the Rules of Professional Conduct. Now, that hearing also addressed the additional allegations of misconduct filed by the Disciplinary Council on August 3rd, 2023, finding that there existed probable cause that the respondent violated Rule 4.4 of the Rules of Professional Conduct. The hearing also addressed the additional allegations of misconduct filed by the Disciplinary Council on July 22nd, 2024. Hey, Bridget, good to see you. Welcome, T42. Oh, yeah. Now, the hearing also addressed all these allegations because finding that there existed probable cause that the respondent violated 1.5c of the Rules of Professional Conduct. Now, notice that the May 1st hearing was mailed to the complainant, respondent, and pursuant to the practice book, Assistant Chief Disciplinary Counsel Marie-Louise Villar pursued the matter before this reviewing committee. The respondent was represented by attorney Cameron Atkinson. The complainant appeared remotely and testified. Remotely. Why? Because he was out of town. She was out of town. The respondent appeared remotely and testified. Why? Because he was probably hiding out in Romania or wherever foreign country he could take his ass to. Now, this reviewing committee also heard the testimony of Robert Richardson, Gail Thompson Allen, witnesses for the respondent who both appeared remotely. No exhibits were admitted into evidence at the hearing. 2 exhibits were admitted into evidence after the hearing by agreement of attorney Villar and Atkinson. Now, between the date of the probable cause finding and the May 1st hearing, this matter had a lengthy hearing procedural history. Imagine that. A lengthy one. On January 25th of 2023, Rinaldi filed an appearance on behalf of the respondent. On the June 22nd, 2023, the respondent filed a motion to dismiss for undue delay, lack of probable cause, refusal to specify probable cause, motion to dismiss. Because he couldn't just put in a motion to dismiss. On July 13th, 2023, Disciplinary Council filed an objection to respondent's motion to dismiss. And on July 31st, the respondent filed a reply to the objection of the respondent's motion to dismiss. On the 31st in 2023 of July, a hearing was scheduled for September 14th, 2023 to hear argument regarding the respondent's June 22nd, 2023 motion to dismiss. Now, on August 3rd, 2023, they electronically filed an additional allegations of misconduct, finding there existed probable cause that the respondent violated Rule 4.4 of the Rules of Professional Conduct. Notice that the additional allegations of misconduct was sent to all parties electronically and via regular mail on August 3rd, 2023. Now, also in 2023, the respondent through counsel filed a reply to additional allegations of misconduct, and the Office of Chief Disciplinary Counsel issued a subpoena seeking to compel the respondent's appearance. No, imagine that. Issued a subpoena seeking to compel the respondent's appearance at September 14th hearing regarding the motion to dismiss. Now, on August 18th of 2023, which would have been 2 days later, Disciplinary Counsel filed a reply to respondent's reply to the reply of the objections of the respondent's motion to dismiss. Respondent's reply to additional allegations of misconduct, support a response motion to dismiss. All one phrasing. Now, on August 24th of 2023, just a few days later, Disciplinary Counsel filed a supplemental reply to respondent's motion to dismiss. And on August 25th, the respondent filed another motion to quash the subpoena and respond to OCDC's supplemental reply. Now, on September 7th, via email and letter, reviewing committee of the statewide grievance committee continued the hearing scheduled to take place on September 14th to allow the parties an opportunity to resolve the pending subpoena issue. On September 11th, 2023, respondent filed a motion for specification of misconduct alleged. A hearing on this matter was scheduled for November 9th. After consideration on a reviewing committee of the statewide grievance committee denied the respondent's motion for specification of misconduct alleged, and then the respondent filed another motion to continue the hearing, citing a conflict with deposition the respondent scheduled for that date. Well, said motion was considered, and on the 17th, a review committee of the statewide grievance committee granted response motion to continue. And of course, on November 20th, well, the respondent, he filed a request for January or February hearing. A hearing was scheduled in this matter for January 11th, 2024. Nice. Citing a conflict with the respondent's counsel's schedule, said motion was considered. Now, on December 8th of 2023, a review committee of the SGC granted the respondent's motion to continue the January 11th hearing. And in December, a hearing was scheduled on the matter for February. In January, a letter was sent to the parties electronically via regular mail, classifying that on the 24th of February, or February 8th, 2024, the reviewing committee would hear arguments on the respondent's 2023 motion. And that unless the reviewing committee granted said motion to dismiss at close of argument, an evidentiary hearing on the merits of the case would follow immediately. Now, he filed a motion to dismiss for lack of jurisdiction. Now, this is going to become really important because this is the kind of filings that he does. So he plays in other people's backyards and then jumps out of there and says, well, you can't do anything because I'm not there anymore. The respondent filed a motion to continue the February 8th committee hearing due to a medical issue. Yeah, you got high. Said motion was considered, and the January 30th, 2024 reviewing committee of the statewide grievance committee granted their motion to continue the hearing. Now, on March 14th of 2024, imagine this. Now, some of these dates are starting to coincide with other things, aren't they now? The respondent filed a motion for ruling on papers regarding his motion to dismiss for lack of jurisdiction. Said motion was considered, and on the 8th of April, 2024, the undersigned reviewing committee of the statewide grievance committee granted the respondent's motion for ruling on the papers regarding his motion to dismiss for lack of jurisdiction, and yet again, denied the respondent's motion to dismiss for lack of jurisdiction. On the 21st of March 2024, a hearing in this matter was scheduled for May. Now, around April 21st and 23rd, the respondent issued subpoenas to attorney Michael Giorgetti and Gregory Benoit, grievance panel counsels, attorney Douglas Butler, a former assistant chief disciplinary counsel, attorney Michael Bowler, former statewide bar counsel, seeking to compel the four attorneys' appearance and testimony at the May 2nd, 2024 hearing. Now, on April 29th, 2024, in Giorgetti v. Bruce Matskin, HHGV, and there's one, Judicial Branch Legal Services, filed motions to quash respondent subpoenas on behalf of Benoit, Giorgetti, Butler, and Bowler. Now, on the 2nd, the undersigned reviewing committee heard arguments regarding the respondent's motion to dismiss. The matter was then taken under advisement. At the respondent's request, following arguments on the motion to dismiss, the evidentiary hearing in this matter was continued to allow parties time to resolve the pending subpoena issue. Now, the undersigned reviewing committee denied the respondent's motion to dismiss, and in May of 2024, respondent filed a motion for reconsideration of the 2024 decision. The 24 decision, the respondent motion to dismiss was reconsidered and again denied. He just keeps filing a motion to dismiss, and they say no. Giorgetti v. Matskin, the granted the plaintiff's motion to quash the respondent's subpoenas. Now, the disciplinary counsel filed additional allegations of misconduct, alleging that he violated 1.5c of the rules of professional conduct. On the 13th of August, 2024, a hearing in this matter was scheduled for October 3rd. Oh, I never saw you sneak in. Good to see you. Hey, how you doing, Rosalind Joe? Does it sound wet? Sounds funny. That could be me. Could be me. Ducey fought this discipline no, he fought it since 2022 of something that happened in like 2019. Yeah. It's giving you a timeline here, giving you a really big timeline. Let me see if maybe I changed something here that isn't quite right. No, it seems like it's good. I don't know what you mean by wet, but okay. So let's see. The hearing for this matter was scheduled. The motion continue. Another motion to continue. The next regularly scheduled hearing was on November 7th, 2024. Some of these dates starting to sound familiar. Now, all parties are advised to notify us immediately if they're unavailable for either of the dates referenced above. Now, the respondent, of course, because that's what dumbass does, he notified via email that he needed to open the July 8th, 2024 judgment, quashing his subpoenas, and stated it would be premature to schedule an evidentiary hearing in this matter until after the outcome of those proceedings. So, more delays, since that's what Deuce does. He likes to delay. Going back to lurking, lingering, and loitering while you lurk. Oh, sounds good, T42. Take me along. July 8th, 2024 judgment quashing subpoenas and stated it would be premature. The stay was conditioned on the respondent's timely moving to reopen the July 8th, 2024 judgment quashing the subpoenas. Now, around November 8th of 2024, the 4-month window to open or set aside the July 8th, 2024 judgment pursuant closed. The respondent did not file a motion or open or set aside the judgment quashing subpoenas with the statutory provided 4-month period. And on December 12th, 2024, the parties were asked via email to advise as their availability for a hearing in this matter to be either held on February 6th of 2025 or March 6th of 2025. And on December 12th of 2024, counsel replied that she was unavailable for a hearing on either of those dates. On the 16th of December 2024, the respondent replied via email that he planned to subpoena former Assistant Chief Disciplinary Counsel Douglas Butler for a deposition, that the scheduling of the contested hearing should await the outcome of any proceedings connected to his desire to depose Attorney Butler. Now, the hearing was scheduled on matter for March 6th. Now, in February, the respondent's counsel, Donald Rinaldi, filed a notice of withdrawal of counsel. Wonder why? Withdrawing his appearance for the respondent in this matter. Because, well, he was in a little bit of trouble himself, if I'm not mistaken. The respondent filed a motion to continue the March 6, 2025 hearing to July 2025. Are we starting to come up with some dates here? And Sister Sal, how you doing, girl? Good to see you. Good to see you. Sister Sal just gifted 5 memberships to you wonderful people.
Welcome to the
Queen B, welcome. Here and after 2, 3, 1, 2, 3. We also got Gina and Liz Tack. Good to see ya. Welcome. Wednesday. Yes, and 4 more days of increasingly stupid, ridiculous, ignorant, bald, or dash poppycock bollocks and fuggery. Oh, yes. Ooh, I love it. Thank you so much, Sister Sal. We need the rain. Gotta find the positive. Yeah. So, respondent filed a motion continue March 6th hearing of 2025. Now, represented that he intended to subpoena Attorney Butler and that continuance was warranted to enable any proceedings in connection with that subpoena to resolve. The respondent also stated he would represent himself pro se until he retained new counsel. Now, in February 11th of 2025, the undersigned reviewing committee granted in part the response motion to continue. The hearing was continued to May 1st, 2025. The notice of continuance stated that there will be no further continuance, absence extraordinary circumstances. Any issues regarding obtaining new counsel or deposing witness must be resolved by the May 1st hearing date. Bold print in the original. Yeah, they were sick of his shit. On April 21st, the respondent filed a motion for continuance of the May 1st, 2025 hearing, asking that the hearing be continued until October. The respondent cited a need to obtain representation, the unavailability of witness, and the involvement in federal litigation in Florida that was monopolizing his time. Really? You mean you were wasting time in Florida? Now, if I'm not mistaken, wasn't he out of that case in Florida by October of 2025? Huh. Let me double check. So that would be a lie to them, wouldn't it? Let me pull that up. I'll just go here so that way you guys don't have to see it. I am pretty sure that he was already out of that case by then, wasn't he? Where have we heard that before? Yeah, because he's been out of the case for quite some time. So what other case could be holding him up in Florida? Let me take a look. Let's see. Well, he was in Fed 1 at that point in time. And let's see, we're looking at 1, 2, 3, 4, 5, 23, 4, 5, 6, 7, 8, 9. That's 2026, 2025. Well, let's see. July, and then, yeah, so let's see, 7/15/2025. Let's see, what was 173? So this one here was 10/16 of 2025. There was a status report. No, guess what? April 3rd, 2025. Well, that's not what he said. Huh. Oh, April of 2025. Be continued until then. Okay, that makes sense. That makes more sense. I was going to say, but I was going to say in October. What did he think he was going to be doing something? April 3rd. Okay, I got you. So let's go 4. Let's see, 4. 135. Attorney's fees, undersigned counsel's motions. He was filing bullshit in April of 2025. Yeah, he had just filed a motion to get attorney's fees. Yeah, there was. Oh, wait, no. No, he was already out of the case. No, see, and let's see, we can look right here because the 14th day of April, 2025. Let me show you. Here it is, right here. 14th day of April, 2025, Judge Zachary Belitho granted his motion to withdraw. Interesting. Because right here, he's saying April 21st, he filed a motion for continuance of the May 1st, asking the hearing to be continued until October. He recited a need for obtaining representation, available witness, involvement in federal litigation in Florida that was monopolizing his time. Huh. Take note of that. I'm sure the grievance committee would be like to know that he lies. Grievance committee, page 7. Yeah, see, I like to take notes like this. Page 7. That the undersigned reviewing committee denied his motion to continue the May 1st, 2025 hearing. They denied it to him. Imagine that. Now, in April, he filed in April 29th, which he was no longer part of Hales, filed an appearance on behalf of respondent. This review committee finds the following facts by clear and convincing evidence. The respondent was admitted to the bar. He has no public record of discipline. Around April of 2021, the complaint retained Mitchell and Sheena to represent her in a complaint against her former employer, Electric Boat. On So, like years later, Mitchell filed an affidavit of illegal discriminatory practice with the State Commission on Human Rights. Complaint would be scheduled for a fact-finding hearing. Complaint contacted Miss Micah Notes of Employee Rights. Miss Notes provides services people help seek employment-related claims against their employers. Notes is not an attorney, is not permitted to represent claimants before the CHRO, but she can and does act as a liaison between individuals and attorneys who specialize in employment-related claims. The record does not indicate when the complainant first contacted Miss Notes, but there is an email from the complainant to Miss Notes dated January 12th of 2022, in which the complainant wrote, "I am ready to pay the $500 for services whenever you guys are, or perhaps we wait a few weeks to see who they assign and then put them on notice. Thank you." Now at 6:40 a.m. on Friday, March 25th of 2022. So January, February, March, 2 more months. The complainant forwarded to Miss Notes an email she had just sent to the attorney for the electric boat referencing confirmed hearing dates. The complainant wrote, "Read below, let's proceed forward. I'm ready to make the necessary payment." Now she replied to the complainant at 10:14 a.m. "Let me confirm with attorney Deuce and confirm his availability. You realize it's $500 per day for fact-finding, right? Unless he can get them to make an offer, in which case it is 25% of the offer. But he requests that they pay him directly so it does not come out of your money." Oh my effing God, spell thingy, stay out of my typing words. They request that he gets paid and then he hands it to you. So he'll take his money out of what they get paid. That's some shady shit right there. The complainant responded, and I'm okay with either. And she responded at 9:24 on Monday, March 28th, 2022, and copied the respondent. Okay, so Deuce will attend the fact-finding with you with the agreement that it is $500 per day. With luck, it won't take more than a day and a half. But I guess we will see. He will also reach out to their counsel to see if they would be interested in settling. If he's able to get them to offer a settlement that you are comfortable with, there is a 20% contingency fee. Please acknowledge that you agree with the above. Once you respond back, I will send his appearance to the CHRO. Once that occurs, however, be reminded the CHRO will communicate directly with him from there on out. That is some shady shit right there. Well, we'll see if we can get him to settle. If not, it'll be $500 a day. That's what he's trying to say, or she's trying to say. The respondent replied 8 minutes later, "Why 20%, not 25? Miss Notes replied immediately with the correction, "I made a typo. It is 25%, not 20. The complainant replied, "Okay, I'm okay with 25%. Let's do it. I'm ready for this David against Goliath victory." This exchange of emails was the extent of the respondent's terms of representation being reduced to a writing. This is why Deuce doesn't like to keep those emails between people like that. You know, AutoCheck is a troll. Yes, it is. The terms of representation being reduced to writing and provided the complainant's written acceptance of those terms. The respondent did not provide a written fee agreement document to the complainant, nor was a written fee agreement document signed by the complainant. So here's what happened. Imagine this. The agreement is he gets paid $500 a day for doing one thing in particular. And that's what it says right here. Bruce will attend the fact-finding with you with the agreement that is $500 per day. With luck, it won't take more than a day and a half, so $750, $800, something like that. So $800 for fact-finding. And what he'll do is he'll see if he can offer a settlement. If they settle, then it'd be a 25% contingency fee. So quick settlement, goes in there. It says, you did it wrong, $30,000 or some crap like that. And then he gets 25% of that. And all he did was basically get them to settle. Mm-hmm. Massachusetts gunning for him too. Oh, I'm sure. I'm sure that they're not too happy. So what happened there? Well, later that morning, the respondent emailed the complainant. Do we have a date yet for the fact finding? Did you file the CHRO on your own? Did there someone at CHRO draft your complaint? Did you file a response to EB's lawyer's 29-page response to your complaint? Do you have a letter from the CHRO retaining the case for an investigation? There's no reply from the complainant in the record. On March 28, 2022, the respondent's appearance was filed with the CHRO. On March 28th and 29th, 2022, respondent exchanged emails with Electric Boat's counsel and Mr. Gerardo of the CHRO regarding the dates scheduled for the fact-finding hearing. Now, on May 20th, 2022, at or about 1:10 p.m., the complainant called the respondent while he was on another call. He returned her call within a few minutes. The complainant asked why she had not received an update from him in 6 weeks and told the respondent that it was unethical for him to ignore her. Now, the respondent explained that he had an update to share and he would have notified her immediately, but that he would get back to her later that day. And so he sent it in an email. Hi, Cordelia. Please in the future email as to me to arrange a call so I can at least look at it and know what the status is. You retained us for the fact-finding and tried to negotiate a settlement. I have asked you to pay the $500 retainer fee. My understanding is that mediation, you dropped your demand to $15,000, but they did not increase their offer from the $5,000. As of late March, when you contacted us, there had been no response, and so I emailed our counsel and to ask for a response to $15,000. None was received. I told her that I needed her to determine if her client would agree to pay you the $15,000. And if she tells me they would, I will then and only then get your authority to offer that. If they won't settle, you will need to decide if you want to wait for September fact-finding or go to court. You can go to the court after the fact-finding as well. The complainant replied, "Good afternoon. I'm super confused. I would have thought that you would have called me within the last 6 weeks." Well, he replied, "I was waiting for their lawyer's response to the settlement proposal, the same one you made at the mediation, $15,000. And she didn't respond since late March when she and I spoke. I emailed to remind her. Nothing has changed in 6 weeks. The case is scheduled for fact-finding in September. Until then, nothing will happen in the CHRO. If they want to settle, their lawyer will respond to me. If you want to file your case in court, you can do that, as your prior counsel explained. Although that involves costs, CHRO does not. If their lawyer does not respond about settling, I would advise waiting until September, and maybe the fact-finding approaches, they would be more incentivized to settle." She replied, "Is it not against model rules of professional conduct for her not to respond? That is so strange, considering she responded to me all the time." He said, "I have emailed her and will follow up." No, it's not against the rules. She may have forgotten, or it may have been their decision not to respond for whatever reason. At 3:39 on Sunday, May 22nd, the complainant sent an email to the CHRO. Miss Notes and the respondent, "I'm releasing attorney Bruce Matskin as my attorney." That evening, the respondent emailed the complainant and copied Miss Notes. "Hey, Cordelia, it's my duty to advise you that if you no longer want to settle on the terms I conveyed to them, $15,000, you need to notify their counsel that you rescind that offer or they can accept it." Ooh, I'm sure what your point was to retain me to enter an appearance in your CHRO case to try and negotiate a settlement only to release me, but I expend a considerable amount of time, including reading an incredibly lengthy filing by the respondent that you forwarded so I would know the defenses they raise. Nothing would happen in your case until the fact-finding, as Mike and I explained. That I conveyed an offer to them and they have not responded to it changes nothing. You owe me. Under the law, given that you've chosen to end my representation of you, I am entitled to be paid for the time I expended on your matter. But she didn't think you did shit for her. That's the thing. You're late. Late mug raid. Welcome, mug raiders. Welcome, welcome, welcome. sliding in from Tug. We love it whenever you slide in, and most definitely.
Welcome to the shit show.
I love it that you're here. Love it that you're here. I spent at least 5 hours on your matter. Ooh. I will forego any percentage or further fee if you pay the flat fee of $500 by the end of this week. The reason I insist on this symbolic fee is because you have wasted my time. In the past, I've had clients who have released me only to shortly thereafter accept settlement offers I negotiated so they could avoid me taking my agreed percentage. If you want to pay $500 for the time spent on your matter, I will notify counsel for the respondent that I claim a lien in the amount of 25% of settlement proceeds. Again, to remind you, if you no longer want to settle on those terms, you should make sure their counsel is told that any offer to accept that amount to settle your case is rescinded. Ooh, getting pissy. Now, they responded to the complainant responded to him Monday morning and said, consider yourself lucky. I could file a grievance against you for legal malpractice. In addition, there is no contract agreement, lack of communication, and you were non-responsive. The law states that a lawyer shall represent a client zealously and diligently within the bounds of the law, which you have not. When I called you on Friday, 5/20/2022, that was the only time we had spoken. You may have made no attempts to speak with me as your client, and you've made little or no effort to speak to EB's counsel. Well, he responded back, your threat is noted. Please remit $500 or I will protect my 25% fee. And she responded, your threat is duly noted. Do what you need to do, and I shall do the same. She was copied on this email thread, and she emailed the complainant and responded at 9:38. She noted that they both agreed to the respondent's fee via email, which was $500 a day for fact-finding plus 25%. She noted that no payment had yet been made to the respondent. Bad thing to do. You should have paid her. Then added, Bruce, I suggest you waive the $500 fee. I will take the hit. You do not have to pay me for my hours that I worked on her matter. Or D, I suggest you accept the waiver and in turn withdraw the grievance, and both of you just be on your way. The respondent emailed counsel for Electric Boat. Why would he do that at 8:45? Please be on notice that should Miss Jones accept a settlement prior to fact-finding, I claim a lien on 25% and ask for that counsel's firm to hold 25% escrow until it receives legal instructions for disbursement. That's some shady shit right there. The respondent replied to Ms. Notes, to be clear, I cannot waive any fee I'm entitled to as inducement not to file a grievance. If Cordelia wishes to file a grievance, I invite her to do so, and I will respond. As far as I can tell, she feels that me not contacting her to tell her that her lawyers had not responded to the settlement proposal I conveyed is somehow an ethical violation. I'm not sure what malpractice she is referring to. I would never do malpractice. I would just waste a bunch of time. Now, on May 24th of 2022, Miss Jones, dear Miss Jones, since you failed to refuse to pay the flat $500 fee as agreed and release me in order to avoid paying it, I am billing you for the time extended on your behalf. I'm willing to cap it there, but I charge an hourly rate of $350. The balance due is $1,750. Alternatively, I will accept your agreement to have the 25% settlement up to $15,000 should settlement be reached. Or you can pay me the $500 fee today at 5 p.m., in which case I will release any claim. And you can send it via Venmo or mail or check or address. If you mail the check, please be sure to alert us by 5 p.m. that it's being sent. Threatening a grievance will not get me to waive my fee. I look forward to responding to any grievance you file. And then on June, he said, in order to avoid the necessity additional cost of filing most small claims, blah, 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 just more fact-finding, allow you to take the time you took from me. He's spending a lot of time writing these. To be clear, I'm ethically precluded from offering you monetary incentive, such as forgiving the $500 you owe me. Oh, gang. Won't do malpractice until I get caught doing malpractice. If I'm not mistaken, you claim that somehow unethical for me to suggest truthfully to the defense lawyer that you could take your case from the CHRO to court as negotiating strategy. I invite you to file a grievance over this or any of the grounds you believe you have. Because I will take and waste your time at court. Yes, I await any note of any grievance you have filed, will file. Go ahead, woman. Do something. Go step up. Around August of 2022, the complainant settled her case with Electric Boat on her own. Before distributing the settlement proceeds to the complainant, the counsel for Electric Boat contacted the respondent to inquire how much he sought in attorney's fees pursuant to his May 23, 2022 email claiming the lien. Respondent and Electric Boat mailed a check to him in the amount of $1,000. The respondent deposited the check. The instant grievance complaint was filed on June 2nd of 2022. On October 3rd of 2022, the Wyndham Judicial Grievance Panel found that there existed probable cause that the respondent violated Rule 1.5 and 1.5C of the Rules of Professional Conduct, and the matter was referred to the OCDC. The original letter read, R's claimed fees letter does not provide that he is entitled to an hourly fee of $350, nor does it provide that in the event that C terminated his services, he would be entitled to an hourly fee. Further, it does not address his rights to any settlement agreement prior to his termination, subsequent acceptance of a settlement offer made prior to termination but accepted after termination. R claims his fee agreement provides for a $500 retainer. However, there is no mention of a $500 retainer in the emails asserted to constitute the contingent fee agreement. Based on these findings, the panel finds that there's probable cause to believe that Deuce may have violated one or more of the rules of professional conduct in his representation of Miss Cordelia. Now, they weren't too happy with that. The panel concluded that the exchange of emails can satisfy the requirement for a written agreement, but noted again that there was no support in the emails alleged to contain the respondent's fee agreement of the $350 per hour he later suggests he was due under the theory of quantum merit, and that together with the sparseness of the email correspondence is sufficient for probable cause purposes to support the belief that he may have violated those rules. I think he's pretty good at doing those. He just tends to not get caught. My opinion, bitch. The grievance complaint was assigned to Douglas Butler. Now, the respondent sent dozens of emails and placed many phone calls to Butler in the Office of Disciplinary Counsel. Many of these communications sought clarification of the probable cause findings, and several pleaded for the case to be dismissed. In a letter dated December 19th of 2022 and sent to the respondent via email, Attorney Butler notified the respondent due to the volume and nature of his phone calls, he would only communicate via email. Like, stop blowing up my phone, brother. In a letter dated 19th, Butler tried to explain the probable cause findings of the violation of the rules, and he wrote, in relevant part, a contingent fee agreement shall be in writing signed by the client and shall state whether and to what extent the client will be responsible for any court costs and expenses of litigation and whether such expenses are to be deducted before or after that fee is calculated. Now, it must be very clear to notify the client of any expenses for which the client will be liable, whether or not the client is the prevailing party. He's basically saying you didn't do any sort of contract. You sent something through email. He continued, your purported contingency of fee agreement is completely bereft of any indication as to whether or not the complainant Miss Cordelia, would be responsible for any court costs and expenses of litigation during your representation. As a result, your asserted contingency fee agreement does not meet all the requirements for a contingency fee agreement, therefore violates Rules 1.5 of the Rules of Professional Conduct. You fucked up. Now, he latched on to Attorney Butler's writing whether or not his explanation of the rule I just quoted, noting that he only uses whether as opposed to whether or not in describing the attorney's obligations regarding disclosure of any expenses the client would be responsible for. And he argued that since the complainant's matter was a CHRO filing, that there are no court or litigation costs in those cases. There's no need for him to notify the complainant of that fact. On December 21st, 2022, he wrote a lengthy public post on his personal Facebook page. After 26 years prosecuted based on a grammar error, he identified Attorney Butler by name, noted that it was his first year of the OCD, and characterized his as of Attorney Butler's first big cases. The post included a link to Attorney Butler's LinkedIn page and also named and cast an aspersion on the panel counsel for the Wyndham Judicial Grievance Panel. The respondent's post did note that Attorney Butler corrected his phrasing of Rule 1.5c in a subsequent letter the next day. However, the respondent post continued, with no regard for harming my livelihood, my law practice, my clients, or my family, ACDC Butler is determined to bring me to justice for not writing there are no litigation costs in the CHRO. The respondent sent a copy of his Facebook post to the Connecticut Law Tribune. The CLT published an article titled, "I have to sit here and squirm. The solo pussy boy, Juicy, is very worried." In the article, the respondent was quoted, "This is 26 years of perfect clean record. My reputation is important to me. I am very proud of it." You're so proud of it that you emailed a judge in a in a state court in Florida, telling them how to do their job. You are so proud of your mama must have been proud. Your mama was so proud of you, little pussy. Oh, you're such a special little child. My reputation is important to me. I'm proud of it. People look up to see if you have some sort of disciplinary record. Yeah, because they want to see if you've done shit like this before. Yeah. You just never got caught. My suspicion is that right there would have probably put a damper on being able to, fleece people for shit. You have no idea what kind of harm and impact on livelihood a black mark has on a disciplinary record. If I can't abide that, and I can't abide that, it's too important to me. I'm trying to make a living here. I have a kid in college. I'm not going to sit back and let this guy think that he can do this for this nonsense. Well, it also included comments from Mark Dubois, former chief disciplinary counsel, who noted the rule requiring attorneys to provide a fee agreement is not precisely written, but the rule is the rule. Even if you're not going to charge a fee, you have to give them a letter. Doesn't matter what Butler wrote, you need to give them a letter. You need to have them sign it. It needs to be filled out properly. It needs to include all the bullshit that you're going to do and all the bullshit that they're going to do. It's like a little contract, Did you not study contracts in your law classes? Or did you just go to that shitty of a school that they didn't teach you contracts? I'm just curious, Deuce. I mean, which one was it? Did they not teach you, or did they teach you and you just didn't pay enough attention? Or you just thought you were too good for a contract? I mean, it's only going to be, $15,000. I mean, it's not like any big case or anything like that, Yeah, but you still took $1,000 from this lady. Huh. Wait, if you're a scuzzy lawyer, you may want to fly straight. Possibly. The Law Tribune published a letter from the respondent clarifying the issue for disciplinary matter. The letter respondent stated that he had sent a copy of his post to the Tribune report and explained that, unbeknownst to me, the reporter sent the respondent's post to Attorney Dubois for his opinion, and that Attorney Dubois' interpretation was that the respondent committed a minor misconduct, expected a free pass. The respondent wanted to clarify that the matter was instead about an abusive disciplinary counsel abusing his power to disrupt the practice and life of a lawyer and threaten a clean public record with a made-up charge. You threatened this lady. Oh, you're good at threatening women, aren't you? He must have big issues with women. Did your mama not love you enough? I'm curious. Did your mama not care? My point was that this is abusive because it is. It's clear Mr. Butler is not pursuing this because of any misconduct. That's because he's determined to blacken my record. Racist Monster Bruce. In February 6th of 2023, the respondent wrote another Facebook post on this matter titled, "Updated prosecuted on a grammar error." This post further described Attorney Butler's unscrupulous and seeking a notch in his belt. This sounds familiar, doesn't it? This is like the same kind of shit that you were throwing shade about. Oh, let's see. Just about anybody that you deal with. It's all a big conspiracy against you, Bruce. We're writing a book about it. You're not really here. You're actually, I hate to tell you this. Did you ever see the Truman Show? You're Truman in this. See, you're just in a giant fishbowl, and we keep fucking with you. Every time that you think you're jumping on a plane to fly, you're really not. It's not happening. You're just in a giant upside down fishbowl, and you have cameras on you the whole time. You and Ray. Don't worry. We'll send people in your lives just to make it seem like they care for you and stuff like that. But really, we just like watching you squirm. Now, the respondent asked on several occasions for the Office of Chief Disciplinary Counsel to file a motion to dismiss his grievance. And on March 30th, Rinaldi emailed the counsel and asked for a proposed disposition pursuant to the practice book. Butler emailed a proposed disposition to Attorney Rinaldi. Butler explained the OCDC will not require the respondent to admit a violation outright, but the proposed disposition would require him to admit that while he denies some or all the material allegations, there is clear and convincing evidence to support a finding of a violation, Rule 1.5c. Now, Butler explained that the proposed disposition required the respondent to complete 3 credit hours. This is it. 3 credit hours of continued legal education, a CLE, in legal ethics. You probably should have taken the course, Deuce. You probably should have taken the course. You wouldn't be in this shit if you hadn't. God. And that, should the respondent agree to those conditions, they would recommend that the grievance complaint be dismissed. Now, Rinaldi sent an email to Butler in which he asked, is the violation that there was no agreement at all, as you told me on the phone, violation that the purported fee agreement was not a complaint due to one or more specific deficiencies? Without this clarification, well, he cannot make an informed decision. He does not feel he can truthfully state what is in that paragraph of the affidavit, paragraph 6 of the affidavit. He's not asking for anything in the draft you sent to be revised, only for your written clarification in an email to me. Like, clarify for me. What, because you can't read? 18 minutes later, Butler replied, OCD is withdrawing the offer of the 2-82 agreement to your client. SGC will notify you when that contested hearing is scheduled. I consent to any request that you and or your client appear remotely at the hearing. Now, that disposition was never signed by the respondent or submitted for consideration by a review committee. The respondent submitted the email exchange cited above into the record as an exhibit. They filed additional allegations of misconduct against the respondent on August 3rd of 2023, citing the volume and tenor of the respondent's phone calls, emails, public postings. Sound familiar, Deuce? disciplinary counselor alleged that the respondent violated 4.4 of the rules of professional conduct by using means of communication that had no substantial purpose other than to embarrass and or burden other individuals, namely Attorney Butler. You've done this before, because the new one that came out against you cited the same damn thing against you. Because that's what you do. You harass, you go after people in the most obnoxious way. What a fucktard. Now, in testimony on May 1st, 2025, the respondent conceded that the emails constituting his purported fee agreement did not include the language authorizing him to place a lien on any award settlement reached by the complainant after his discharge. In the same testimony, the respondent conceded that the purported fee agreement did not cite hourly attorney fees. They also considered the following. He testified she did not retain to represent her in the case. The complainant answered no when asked if she recalled agreeing to the respondent receiving 25% of any award he obtained for her. However, she wrote in her complaint that she was advised of a contingency fee, and her complaint included emails which she agreed to that. The complaint testified that when she wrote in January 12, 2022, I'm ready to pay the $500 for services whenever you guys are, she understood the $500 was to be Miss Note's fee and not a retainer for an attorney. The complaint testified that she had no contact with the respondent before the May 20th phone call, that she only called the respondent on that day because she was unable to speak with her and told her to call the respondent for an update on her case. If you did not hire attorney Matskin, what was your understanding of who you were firing? In her email, which she wrote, I'm releasing you and anybody else who said they're representing me, but yet wasn't. The complaint testified her payment from Electric Boat was delayed due to the lien the respondent placed on any settlement she was received after she was terminated as her attorney. She testified as a consequence of the complaint she filed. The respondent, she has been personally attacked on various platforms of YouTube. Deuce. You wouldn't do that, would you? You wouldn't attack people on various platforms on YouTube. Poor Miss Cordelia. You took her money and then you badmouthed her on the internet. A private individual. That's pretty damn shitty. Not an officer of the court. Already starting up that little spin machine, huh, Bruce? Now, as repeated of the respondent's media postings and his emails to disciplinary counsel and others, he was an innocent lawyer with more than 25 years of a perfect record, having to endure a targeted grievance and conjured up charges, a manufactured prosecution that was abusive, baseless, nonsense, abusive of authority. I wonder if Cordelia was reached out. I wonder if Cordelia was reached out by people like Paint Chips. I wonder if he, did these mass email chains to her where he just kept threatening to sue her because, he is pretty common to threaten people. Manufactured prosecution that was abusive, baseless, nonsense, abuse of authority, regularly questioned the integrity of the disciplinary personnel tasked with handling his matter. Throughout, he maintained that the actual grievance was nothing more than a fee dispute brought by a former client who was upset that he insisted she pay him $500 for the time he spent on her case before she fired him. The respondent began his argument on his motion to dismiss. But you're not here to save face the abusive proceedings to testify something that should have never gotten this far. Later, he recited his own career credentials. Now, I'm a 26-year lawyer. Perfectly clean record and good standing in 2 states, Massachusetts and Connecticut. Well, that's about to end, isn't it? Because you've got no standing in the state of Florida where you're being, UPL, huh? I bet you really want that bankruptcy case to last, don't you? So you're going to delay that as long as you can, because as soon as that stay is lifted, oh, buddy, does the floodgates open up and the filings start yet again? Oh, my. It just gets crazier.
I'm a serious lawyer. I've had a solo practice since 2004 in Connecticut, now in Massachusetts. I represent people who can't find lawyers. I represent the minimum wage employee, the little people who got harassed at work, and I called around and found 5 lawyers asking for $5,000. Let's file a case. I'm the one that gets their severance and gets them what they're entitled to without having to spend 2 years and thousands of dollars.
Shit. Yeah, liar. You liar. How much time have you spent filing for Lynette? Oh, and you hadn't stopped yet, have you? Boy, that stuff is going to happen. The respondent continued.
Doug Butler is a rookie disciplinary counsel, first of all, and I'm a little offended, if I may be candid, that they would put a first-month disciplinary counsel to make his bounds.
Because it's $1,000. All you had to do was pay the lady back. But you were unethical. You should have never put a lien on her property. You should have just said, hey, whatever, I'm moving on. Moved on with your day. But no. Wasted Jeremy's money for all the extension. Yeah, that's what he thinks. Let's see, the thing about it is, you know, that can be handled so many ways. He just has no idea. Now, on May 1st, 2025, Villar asked the respondent about his many emails to authorities. You engaged in numerous emails through the course's grievance proceeding. Is that correct?
Part of the process. Part of the process. That's correct. Yeah.
And did you continue to ask some of the same questions over and over again, specifically regarding what the PC findings were? Probable cause findings. Do you recall those emails?
I was noting that the probable cause was vague and didn't specify what exactly the misconduct was, in which there was probable cause, and was trying to ascertain that from Mr. Butler. And Mr. Butler would only continuously refer me back to the probable cause. And I'm saying, well, we're talking in circles, because what I'm trying to do is get beyond the probable cause and find out what they're saying I did to constitute misconduct.
Oh, the respondent testified, I believe I was treated unfairly, and discussed the proposed 282 deposition. At one point, it had been offered by the OCDC.
And that's the most unfair thing, that I was ready to stop playing. You know, I didn't want to play no more. And you said, and I wanted to do a 2-18, and we questioned. It was provided an email with a covenant affidavit they were supposed to sign. Invited Mr. Rinaldi to ask any questions or concerns. And he did. And it was, what's the factual misconduct? And we thought that was very reasonable. But 18 minutes later, Mr. Butler emailed back and said, sorry, we're just presenting this shit. So I believe I was treated unfairly. You wasted his time emailing him, harassing him, back and forth. And you know what he said? He said, I'm done. It's very clearly stated what the violation was. It is written in black and white. You can read it yourself. If you don't believe it, you can go look it up.
You are a fucktard. You just wanted to waste more time. And Butler was like, I'm done wasting time. We're just going to resend it. We'll see you in court. You don't have time for this shit. They're just like, you've been wasting. You've been wasting for like half a decade on this shit. And you're still butthurt. Still, to this day. Later on May 1st, 2025 hearing, in response to questioning by his counsel, the respondent conceded his fee agreement was deficient in terms of the information it did not include. No shit. That's why you're in trouble. Did it take you this long to figure that out, Deuce? The question was, and would it be fair to say that after reviewing the emails that represented his fee agreement, that nothing in these emails contemplated how to handle what would happen in terms of fees were you terminated?
That's correct. The answers I did not. I did not say. And by the way, if you terminate me and I spend hours of time, then this is what's going to happen, or this is how much I'm going to seek a quantum merit, and that was not part of my fee agreement.
At some point, did you come to the conclusion that the absence of such language would render your fee agreement vague within the meaning of Rule 1.5?
Well, you know, I'm willing to look. It's not a bad thing to include that. I don't believe that this was the basis for original probable cause of the original grievance by Miss Jones or anything even Mr. Butler was planning on, you know, claiming constituting misconduct. But nevertheless, I intended to include a presumptive hourly rate, even if it would never apply.
I contemplated. Oh, I contemplated. That's glorious, Deuce. That's glorious. You contemplated. Okay, and in this grievance, is this a retainer agreement with Miss Jones? Are you prepared to state that in your agreement with Miss Jones, you had none of that language in there?
Yeah, you mean about the hourly rate in case she reached the retainer agreement and I were going to seek a payment or quantum merit? The answer is correct. I did not include that information.
Attorney Villar then asked respondent to repeat what he had said.
The answer is yes. The answer is correct. I did not include that information. I did not have anything in my agreement that said, look, if you terminate me after I spent hours of time and I need to seek quantum merit, then this is going to be, you know, the hourly rate. And I didn't pull that in there because I didn't think the rule, and I don't think the rule actually requires it, but that's not a bad thing to include.
He can't just take the loss and move on. No, Big Al, he can't take the loss and move on. No Valor News. This here is his first grievance complaint that concluded last year. That had been going on since 2022. Oh, I've heard this before. It's really funny to hear it again. Yes, it is.
And it's not it's not anything anybody picked up on here. It wasn't even, you know, part of her grievance or part of the reasons I was being accused of misconduct.
Yeah. And this agreement with Miss Jones had no provisions about attaching a lien to her settlement as well as her result of termination. Correct.
Correct. And my same explanation.
So, other words, he's strong-armed people before. That's what it sounds to me like. It sounds to me like he's strong-armed people before. That's what it looks like. I mean, because, you know, I never included it before, but, you know, if they backed out of it, well, then I would put a lien on it. Nobody else thought to file a grievance on this. That's what it sounds like to me. In closing statements, the response counsel stated that respondent accepted responsibility for his errors. He testified credibly today, took immense pride in his clean disciplinary record. I would submit to you that this defense's case has been aggressive, but what you also heard today from him is his testimony. They admitted he fucked up and that he authorized me to stand in front of this panel and say that this fee agreement could have been better than it was. He testified to that. He also testified that to you that he would be working on correct that going forward. Yeah, he's a bully whining. Yeah, he's a bully, a whining bully. He starts something, and then whenever he gets called out on it, he cries about it. He'll sit there and harass and strong arm people and force them and be a bully. Love your mails, Tillis. Thank you. They conclude that the attorneys find it prudent to draft a template, blah, blah, blah. The record does not contain an email explicitly referencing a $500 fee until the response email to that. The respondent cites a complaint email to Ms. Notes in which she said, I'm ready to pay the $500 for services. Proof that the complaint had previously been informed of the $500 retainer fee. Further emails from Ms. Notes, the complaint stated the respondent would be due 25% settlement offer. There was no language in any of the emails to the record authorizing respondent to submit a claim. Respondent lack of evident advanced disclosure of the $500 retainer fee he had later demanded, and his post-termination placing the lien on any settlement and complaint. The respondent violated Rule 1.5b of the Rules of Professional Conduct. Yeah. The reviewing committee does not find clear and convincing evidence of the rule of violation of Rule 1c of the Rules of Professional Conduct. The respondent expected contingent fee percentages. It also notes blah, blah, blah. These are just the rules. Here, the facts of this case are distinguishable. The committee also does not find clear convincing evidence of Rule 4.4, Rules of Professional Conduct. Representative, client, or lawyer shall not use any means that have no substantial purpose other than to embarrass, delay, or burden the third person, which he did. Respondent was alleged to have violated that rule in several ways. His extreme high volume of emails and phone calls was purposeless burden on disciplinary personnel. His public postings, articles serve no purpose other than embarrass disciplinary personnel. And see, this is what the thing is about it is, you know, they're state employees or basically government employees. So yeah, it sounds like he violated it. No, you have to understand. Just like we learned in watching the Afro Man trial, that government officials, you have to meet a higher standard for a lot of things because they're held to a higher standard. For you to violate those kinds of things, it's a different standard. It's the way it goes. Sounds like he violated it. Sound like he was born on Sesame Street. While many of the respondents' emails and public media posts may have been ill-advised, this reviewing committee does not find clear and convincing evidence. The review committee, blah, blah, blah. We order the respondent to make restitution to the complainant in the amount of $1,000 representing the attorney fee and the respondent received from the complaint settlement. The respondent shall pay said restitution with 30 days of this date, and the respondent shall provide the copy of the check when sent to the Office of Chief Disciplinary Counsel. $1,000. 10/17/2025, right there. That right there is the decision that this date was made. But it doesn't stop there, because he is back in front of them yet again. State of Connecticut Judicial Branch and I've pulled out addresses out of here. Grievance panel finding of probable cause. The above captioned grievance was considered at a meeting held on March 13th, 2026. Just a few days ago. The panel carefully reviewed the information submitted and made its determination without a hearing. Based on the panel's review of the information submitted and at its disposal, the panel has determined that no investigative hearing is necessary and, well, none has been conducted. This complaint involves an ongoing dispute in which the complainant and attorney involved in litigation as representing one of the parties to the litigation contends that the respondent, who is not licensed in the jurisdiction where the litigation is pending, has been involved in the unauthorized practice of law and that he has been sanctioned by the presiding judge in the case. The complaint contends that the active involvement of the respondent in the state of Florida court case is inappropriate as he is not a licensed attorney in Florida, nor has he been admitted on a pro hoc vice basis. He further alleges that the respondent has unprofessionally and without good reason disparaged him in email and other submissions that he has made in the case and to others involved in the litigation. He submits that the actions of the respondent, which would be Deuce, have constituted conduct that is prejudicial to the administration of justice in violation of the rules of professional conduct. The complaint references several other rules of professional conduct which it is alleged have been violated by the respondent. Now, further, the complaint challenges the solicitation of funds by that respondent through an online effort. Appended to the complaint were examples of pleadings that were filed in the litigation, which the complainant contends were ghost-ridden by the respondent. The respondent filed an answer through counsel to the complaint defendant defending the respondent's involvement in the matter, which would be Deuce, responded, denying that his involvement constitutes the unauthorized practice of law in Florida. So filing before ghostwriting may not be illegal in Connecticut. That's what it sounds like to me. Now, in the state of Florida, it is very illegal, and you can get a lot of trouble for it. Yeah. This dispute, the dispute has raged on the internet through the YouTube channel. The YouTube channel? Like one channel? Is YouTube just one channel? Like you turn the dial and you turn it. Man, let's go watch the YouTube. Come on, mama. We're going to go watch the YouTube. Counsel for the respondent contends that this grievance panel does not have jurisdiction over the complaint and notes that the respondent, although licensed in the state of Connecticut, resides in Massachusetts, where he is also licensed. The answer contends that there is no meaningful involvement of Connecticut in the matter, except you're making Connecticut look really bad. And they don't like their attorneys pulling shit like this. As for the emails and the other information sent by the respondent to the courts of Florida, these documents constitute protected speech under the First Amendment to the U.S. Constitution. Really? Really? Telling a judge that they need to respond or how they need to respond, and here's the filing, and writing those filings and telling your client, former client, which she fired you or you quit or whatever the story happens to be that fits best for you this particular day. These documents constitute protected speech under the First Amendment to the Constitution. The answer does not acknowledge that the respondent was the author of the submissions to the court as pleadings and suggests that the submissions could have been created by AI programs readily available. No. No. Are you saying you use AI now, Bruce? You know, that's a different rule right there. Hey, maybe Bruce will reference my letters. The answer specifically states that there is no hard evidence that the respondent has made these filings. This suggested that there is no evidence to determine that he has authored the pleadings, and that it's nothing other than the belief of the complainant. It's only their belief. Oh, guess what, Deuce? You can contend that all you want to, but you know who has proof of that? You know who has proof that you wrote those filings? A certain lady that used to be your client said that you wrote all of those. Right, Bruce? If you don't believe me, I'll tell you what. I may have to search for it, but maybe that's what I'll do this weekend. Is I'll pull up those phone messages that you had with her, or that she had with you. You know, where she tells everyone that Bruce wrote her filings and was continuing to write her filings, that she needed you, Bruce. Or maybe they can pull up the part where you told on a panel, how many times did you say it, that you were going to be working in the background on this? That there was nothing that they could do to stop you from working in the background now that you're out of the case, that you could continue to write stuff for her and she could file it. Remember that? Yeah. Yeah. See, even your own words are going to burn you, Bruce. All that stuff has been recorded and saved. All of it. And you thought people forgot. I think, Bruce, this is the part of FO, of FAFO, is what's coming down on you, son. The answer specifically states that there's no hard evidence the respondent made the filings. It suggests that there was no evidence to determine that he's authored the pleadings, that nothing other than the belief, except for John Cook's own testimony in this. Oh, and Felisa didn't help you out either. She burned you big time. I guess maybe you should have represented her whenever she was asking for all your help, and you told her, you know, you're making us all look like fools. Because, well, they are. They're laughing at us. They're laughing at us. Oh, Bruce, you must really be butthurt right now. Just go ask Paint Chips. He knows about butthurt. Yeah, he got butthurt over and over and over. Yeah, he also said he didn't know Ohio court. This suggests there's no evidence to determine that he's the author of those pleadings. Yeah, there is. Other than the belief of the complaint. The answer is when an individual addresses with the specific rules of violation, alleges and denies each in such allegation with regard to the order of the presiding judge involved in the Florida litigation that the respondent is engaged in with regard to the order of the presiding judge involved in the Florida litigation, that the respondent has engaged in the unauthorized practice of law, and that the order specifically enjoined the respondent from any further communications with the court. Along with the admonishment of the respondent by the court, counsel for the respondent submits that the order of the judge violates due process by purporting to discipline the respondent without the basic notice and opportunity to be heard required by the 14th Amendment due process clause. I don't think that's the case there, Deuce. See, here's the trick about it, Bruce. You got your ass in trouble. Sucks, doesn't it? Did they violate his rights by the 14th Amendment due process? Or had the judge told you, and the lady already told you, stop emailing the judge? Because I'm pretty sure you're not counsel for Lynette. Yet you were emailing the damn judge. Ex parte communication. You were writing the pleadings, showing exactly the pleadings that you wrote. Oh, that right there is going to be difficult for you, isn't it? Because all they have to do is take and show the same language, the same thing that you were doing over and over and over again. And you'll fight it out for what, another few years? You'll argue, you'll kick, you'll scream. Eventually, that will come down on you. And you'll be by that time you'll probably be retired. You're hoping you can delay it until you get retired because that's your behavior. Delay it, delaying the inevitable. And you'll be forever known as the guy got 2 grievances. Maybe 3. You might even end up doing time in Florida. That's going to be interesting. You're going to be fighting 3 cases, 3 separate cases with 3 separate bar panels. And they are going to have a lot to say to you. They're going to be asking you a lot of questions. And you know, you go, well, you have no jurisdiction over me. Well, let's see you try to run from those felonies. Huh? Let's see what happens. The complaint was offered the opportunity to make a reply submission to the answer of the respondent, and he did so. In that reply, he reiterated the arguments made in the complaint and highlighted the actions of the respondent, which allow for no other explanation other than the respondent improperly practiced law in the state of Florida. The reply notes the respondent signed his communications as Bruce Madskin Escuela. The reply challenges the answer's conclusions to the Connecticut has no jurisdiction in the matter. The reply references that the rules applicable to Connecticut attorneys apply regardless of where their conduct occurs. Rule 8.5. You might want to have read it. They're very clear and decisive on this. Yeah, it doesn't matter where the conduct replies. You know, where you pull your shenanigans, whether it's in Ohio or Florida or any other place. The respondent through counsel filed a response to the reply submission by challenging the jurisdiction of Connecticut to handle this complaint and reiterating the lack of due process surrounding the judge's order. And it is noted that the judge's order was drafted by the complainant, as the judge asked him to, and signed off by the judge too. At its meeting, the grievance panel unanimously determined that probable cause exists that the respondent has violated the following rule of professional conduct, Rule 5.5, unauthorized practice of law. Additional rules considered by the panel included those suggested by the complainant in his submissions, which were 8.44, 4.4a, 8.2a, 1.5, and 3.5. As to each of these, the panel determined that no probable cause that the respondent violated these rules. Now, those rules had to do with harassment and those kinds of things. And the judge, the panel decided that he didn't violate any of those rules. Where is Larry? Where does Larry live? Where is Bruce trying to sue him? In Kentucky? As an attorney, they're also in it. Yeah. I believe that Bruce had an attorney trying to do his dirty work in Tennessee. wouldn't be surprised. A copy of this determination has been sent to the statewide grievance committee for the schedule of a hearing. And by the way, you will be notified directly by the statewide grievance committee regarding further proceedings and a hearing. It should be noted that this grievance panel has concluded its investigation into this matter. Therefore, it respectfully requests that any additional filings or responses be submitted directly to the statewide grievance committee. You hear that? Any additional filings or responses, paint chips? If you really want to get involved in something, there you go. Go email them at the statewide grievance committee. Tell them how smart you are. A disbarred attorney, a former convicted felon for kidnapping, abuse of an old man, all those other kinds of shit, you know, the bad stuff that you did. Allegedly. But the stuff that you were convicted for, that right there. Why don't you tell them all about that? Tell them how wonderful you are. Maybe you could file those for him. You know, really help out his attorney. I bet you'd be really good. In addition to a copy of this letter, complete records have also been sent to the Office of Chief Disciplinary Counsel, the telephone number of the office, and the Disciplinary Counsel will be involved in this matter as it proceeds. Yes, sir. Yes, sir. Isn't it wonderful? You put yourself in a pickle, Deuce. Oh, Deuce. You, sir, are in a bit of a pickle. And I wonder what's going to happen with Florida. Wonder what's going to happen in Florida. Do you think they're going to let it bypass? Do you think that Connecticut's going to let that go bypass? And I'm wondering what would be, and I hadn't really thought about it, what would be in Connecticut? If I can spell it right. I can't. Connecticut. Jeez, spell. For what is it? 8.5, I think is what it was. Loving it. I think that's what it was. Double check. Nope, that's not it. It would be right about here. I believe it was 8.5. 5.5. I just want to make sure I was right. For violation of 5.5. Rules of conduct. There we go. Consequences can be subject to disciplinary action by the statewide grievance committee. Ethical violations, practicing in the violations of regulations, a breach of professional ethics, injunctions, restrictions. The court may issue orders restricting the attorney from appearing in local matters such as depositions, mediations, or while it's primarily ethical, unlicensed practice can lead to civil or criminal penalties under. Oh, well, that's pretty cool. Let's see what the civil or criminal liability of 5.5. What is, because that's what they would be looking at. Dive deeper. And if it is if criminal civil liability, what would be the outcome? If found guilty, let's see. Oh, that's pretty cool. If the defendant is an attorney with either use treatment practice in Connecticut without authorization. Oh, that's really bad. Oh, jeez. Oh, you're going to love this. Hey, Hey, Deuce Escuela. I think you know what it is, because if they do find you guilty of this, this is a Class D felony. If found guilty, you could face up to 5 years in prison and or a fine of up to $5,000. Now, if somebody was doing it from out of state, it would only be 3 months in jail and a fine up to $500 in a Class C misdemeanor. There also, anyone found guilty of UPL is also deemed in contempt of court, and the Superior Court can issue an injunction to immediately stop the illegal practice. But the rules of professional conduct, malpractice claims, so Lynette could go after you for malpractice. Rule 5.5 itself doesn't automatically grant a win in a lawsuit. It can be used as evidence of negligence or fraud in a separate civil case. If found liable, the defendant must pay monetary damage to compensate the victim for any harm caused. So you're going to be writing a check out to Lynette? That could happen. Suspension or disbarment for serious repeated violations. Attorney may lose their license to practice law in Connecticut. Reciprocal discipline, a violation in Connecticut, is also often reported to other states where the attorney is licensed, potentially triggering additional penalties. Yeah, that's good. you're in a whole heap of shit there, buddy. I bet that's feeling painful. Maybe you can, hang out with Paint Chips. He'll be your little buddy. He'll show you how it works in a big house. Over and over and over again. Good job. Now, it's going to be funny is I'm sure that the fleas are going to be sitting there going, oh, they're just doing this for YouTube content. Yeah, everything that we do on YouTube is for YouTube content, you fucking dimwits. But of course, Mutton Flops, she's going to be out there saying, well, I read it and it doesn't say what they think it says. Good job, Mutton Flops. You learned how to read. Because apparently you weren't good enough to read the case that you filed. Whatever you had to go back and amend it. They got Bruce so pissed off at you for fucking it up royally. Oh, his retirement gift will be a $10,000 bill. Put his ass in prison. Well, that would be up to the court. I have no say-so in that. I just comment on the shit that I see. Shizzy Bruce's next tat. Enter in rear. Could be. I don't know. That'd be up to him. However he wants to go there. However he wants to do it. I mean, it's not my decision. It's not my decision at all, but I hope that you guys do join me tomorrow night. Well, not tomorrow. Well, I'll probably be doing a stream tomorrow night, but tomorrow day, most hopefully, depends on how busy my day gets. Tomorrow night, I'll be on FNL. Tomorrow morning, I'll be with Mo in the Deep End. Tomorrow, sometime during the day, I may set it up to do it after morning with Mo. We'll see. But my plan is I will probably schedule it. Make sure that you got the notifications turned on so you can know when that comes up. I'm going to be going over more of the Afroman trial because it just was so damn interesting, and I'm like captured by it now. Highlighting the transcripts that Felicia could narrate was hilarious. Yeah. There you go. Bruce's next. Yeah, this is going to be a very interesting one. This weekend will be. I've got so much. Jeez, there's so much content. I can't even cover it all. That's why I'm doing just a nice evening one tonight, because I knew that I didn't want to start early tonight. I wanted to give you guys, let you guys roam free about. And yesterday was such a blast with Expert. If you hadn't seen the first one, go back, watch part 1 of the Afro Man trial. We had a really, really good time and started understanding that it was crazy. And then, of course, we went until 12:30, 9, 10, 11, 12, almost 3.5 hours, I think is what it was. We went day 1. Day 2, we did it in about the same amount of time. So expect it's going to be a long one. It's going to be a blast. We're going to have probably no drinks except for water. Just, it is Friday, but my plan is to have a nice good stream, low drama, middle of the day, won't be sleepy. You can chat, you can, throw ping pong balls at me. Be weird, but I'll still enjoy it. And with that, folks, I will see you guys tomorrow morning, Mo in the deep end. If you haven't been there, don't worry. It's going to be a blast. We will see you then. Thank you so much for being here and have a wonderful, wonderful night. Peace.
Breaking news or whatever. They're on another one. Gang, gang. Yeah. Gang, gang, emergency Zoom film at 11. Same 5 goons, same deranged obsession. This changes everything. Bro, it's page 47 of emotion they skin while half watching Yellowstone. Gang, gang. Squinting at 8-point font like detectives. Zoom so far and the pixels are screaming for mercy. Look at this, timestamp 2022, my God. But they're yelling it like they just cracked Watergate. High five. Mike's been muted for 20 minutes, still barking. Circular logic, so a lot of time that's impressive. Trust the plan, this is massive. Nah, fam, it's boilerplate and it's mid at best.
Gang, gang. Self-appointed outrage, swat patting each other like they personally ended corruption. Gang. Dropping bombshell tea that's been sitting in pieces since breakfast. Gang, gang. Moral high ground, speed run, they'll flip the script the second it's convenient. Gang.
Same PowerPoint presentation, new day, same brain dead narration.
Gang, gang.
We're not obsessed, we're just passionate. 3-hour living yesterday's hoodie, passion in my ass. Why is he even breathing right now? Says the guy refreshing notifications every 14 seconds. Gang, gang. Playing lawyer on God mode, reading comprehension. Stuck in elementary, confidence in the stratosphere. Case dismissed. They're screaming to the void. Motion still pending, but go off, I guess.
Disagree? Obviously a paid chill. Actually read the filing, deep state plan. Laugh at them, you're clearly compromised too. Exist in the same zip code, suspicious behavior. Notify the group chat. Gang, 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 gang.
Tighter circle, smaller brain.
Gang, gang.
Echo chamber finally running out of oxygen. Gang, gang. Yeah. Gang, gang, acting the actual judge like it's group chat. Replay all meltdowns, labeled just asking questions. Got warned by the core once, that was a suggestion. Still get it the same screed like it's strictly trash talk. Gang, gang, we're above all this drama. While screenshotting, they on meltdown for content. Preaching peace and love while actively baiting bears. And fake shock when the bear finally bites back. How could this happen?
Gang, gang.
Synchronized tantrum hours. 5 tabs open, all the same screenshot. Different zoom levels, gang, gang. Premature victory lap over legal language, still can't pause.
Gang, gang.
Standing 10 toes on business until tomorrow's finally send them scrambling again.
Gang, gang.
Hype the claim to the moon, then ghost the chat when it ages like milk. Gang, gang.
Gang, 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 gang. Gang, gang.
Refresh. Gang, gang.
Gang, gang, gang.
See y'all same time tomorrow. Don't be late.
And I'm sending you guys over to CMG. He's doing the same thing that I'm going to be doing tomorrow.